Welcome, everybody. It's a great pleasure to invite you to our seminar this afternoon. I am going to very briefly, so that we introduce our speakers, to leave as much time as possible for his talk. And we're grateful today to welcome Professor Rephael Stern of Boston University Law School to speak to us today. The most important things you need to know about Rafi is that he has a Ph.D. and J.D. from Harvard and an M.A. from Princeton, but most importantly, I think you'll agree, a B.A. from Brandeis University. Oh, yeah. And he has many, many awards, accolades, and publications, which you should look up online, because I don't want to take time away from his presentation this morning. And I am very glad to welcome you to Brandeis this morning.
Thank you. Thank you. Yeah. So hi, everyone. Thanks for coming out for this lunchtime talk. So first of all, I just want to say thank you to Alex and to Shayna for inviting me. Thank you to Freddie and Wendy for all the help making sure this happens. So second, I want to say that it's really wonderful to be back here at my alma mater. My 4 years at Brandeis were very formative for me, and the institution's kind of still very near and dear to my heart. I initially came here to play college baseball and study pre-med, but I continued to do those things, but I also kind of pivoted to Middle Eastern history. I was very close with professors Nagma Rafi, Sami Smucha, who was visiting from Haifa at the time, and Shai Feldman and Chil Sheikaki. These professors all were great mentors and showed me the possibilities of history and rethinking my basic assumptions about the past and the present in both the Middle East and elsewhere. I even got funding from the Schusterman Center when it was under Elon Cohen for my, I think it was for my senior thesis. Finally, probably most importantly, at Brandeis, I met my wife, Hetty. Brandeis is a great place. Third preliminary point is that this talk is the first time I'm presenting this research. It's based on research I did for my dissertation, but I would love to kind of get any feedback. So the project today looks at how Israeli lawyers and government officials grappled with the question of defining and demarcating the territorial jurisdiction of the State of Israel following its declaration of independence in 1948. In the initial years of Israeli statehood, there was deep uncertainty about what constituted the territory of the State of Israel, still is. And in particular, there were many questions about the legal status of the territories that Zionist-turned Israeli military forces acquired during the 1948 war that lay outside of the boundaries of the UN partition plan, the boundaries that the UN partition plan had allotted to the Jewish state. So in this talk, I'll lay out some of the evolving legal understandings and reasonings of Israeli claims to these territories and show how Israel eventually came to assert jurisdiction over the territories that became known as the territories within the Green Line. So the talk today won't focus on the post-1967 period, but the arguments and legal categories that they were first created after 1948 and first considered in these formative period also kind of informed the ones that were put forth and the arguments that were put forth after 1967. And I'm happy to talk about those in the Q&A. So I've divided the talk into three parts. So first, I'll introduce the problem that arose as Israeli lawyers set out to define the legal status of these territories. So I'll focus on the views of Ministry of Justice lawyer Yitzhak Shiaki and Attorney General Yaakov Shimshon Shapira. They were kind of the centerpieces in this story. And I'll discuss how they come up with this idea that Israel is in fact occupying these territories, belligerently occupying these territories under international law and is bound to the 1907 Hague Convention. Then I'll discuss how they themselves and others gradually shift to argue that no, these territories are not belligerently occupied, that they are in fact quote unquote administered territories, shetach muchzak, rather than shetach kavush, conquered or occupied territory. They create this new category. They're very well aware of that fact. And at the same time, they kind of extend Israeli law and jurisdiction to these territories, while at the same time understanding that they're inventing a new legal concept. So, it's working. Sorry. Also get the mouse and just do that.
Tested it before.
Maybe so, Freddie, can you go forward?
Go on the screen. Yeah.
Okay.
Okay, great. Right. So when the State of Israel declares it, or when the State of Israel declares its establishment on May 14th, 1948, the question of its legal basis and borders were deliberately left ambiguous. David Ben-Gurion and other leaders predicated their declaration on the quote-unquote historic right of the Jewish people And in far more equivocal language, they spoke about the strength of the resolution of the United Nations General Assembly, right? This is talking about the partition resolution from November 29, 1947, regarding partitioning Palestine into a Jewish state, an Arab state, and an international enclave. Whether this mention of the partition plan meant that Israel would be established within the plan's proposed borders was not answered, right? After all, there was complete silence on the matter of borders. This omission was intentional. As one Israeli lawyer remarked at the time, Ben-Gurion did not specify the state's borders in order to avoid formally committing to the partition plan's quote-unquote artificial borders. As many scholars have noted since, this silence was strategic and was intended to keep Israel's options open as the eruption of full-scale war loomed. Yet maintaining the silence as to where Israel had territorial jurisdiction quickly became untenable. So in particular, as Israeli forces quickly took over and solidified their control in the territories beyond those earmarked for the Jewish state in the United Nations plan, including in West Jerusalem, parts of the Galilee, and the corridor to Jerusalem, Israeli political and legal leaders confronted an unavoidable dilemma. Under what legal framework did Israel govern these areas? So here we have the territories of the partition plan, right? And then here's some of the territories of the first truce. It's kind of hard to see, but Israel already starts kind of making inroads, both kind of within that corridor to Jerusalem in the middle of the map, and also in the northern Galilee. They quickly occupy lands, especially up top, right? I'm coming to up top next to the Mediterranean Sea. And then by the second truce, they've kind of solidified that even further. So section 11 of the Law and Administration Ordinance 1948, the first law that was passed, stated that the existing law would continue to remain in force. This provision raised a whole host of questions, right? But for our purposes, one of them was, where did it remain in force? While there was consensus about applying Israeli law within the UN-defined Jewish state's borders, the status of law in the other areas was hotly debated. This Israeli constitutional and jurisdictional question intersected with an international legal one about the status of these territories. So in June, Freddie, I think you need to go back onto the PowerPoint. Thank you. If you just click on the PowerPoint. Yep, awesome. Okay. So in June 1948, around the time of the first truce, Israeli governmental lawyers, especially in the Ministry of Justice, started to consider this issue in depth. So two figures here were especially important. The first was Attorney General Yaakov Shimshon Shapira. He was originally from present-day Ukraine, and during the mandate period, he moved to Palestine, and he represented many Jewish immigrants, especially those who had attempted to enter Palestine illegally. The second one was Yitzhak Shaki, formerly Isa Koshiaki. He was born in Thessaloniki. He taught philosophy in the 1920s and 1930s in Italy, where he was also a leading theoretician and ideologue of revisionist Zionism. Became very close to Jabotinsky while he was there. Eventually, he abandoned his flirtation with fascism and Mussolini and immigrated to Palestine when the race laws were imposed in 1939 in Italy. And in Palestine, he reinvented himself as a lawyer rather than being a philosopher. So, you know, if all else fails, you always can become a lawyer. That's something I learned as well. So from the outset, both of them evinced this this belief that the situation in Palestine, cum Israel, right, was in fact sui generis, right? So it was unique. But they also sought to determine the international legal status of these territories through analogy to existing categories of territorial acquisition and control. So they considered 5 options in their internal memos. So the first one was this idea of conquered territory and conquest, right? And kibush was kind of the technical term of it. Kibush was also used, as we'll see, for occupation at times, but there was kind of a specific meaning for conquest. So conquest had long been a primary mode of territorial acquisition, but over the course of the 20th century, it had become increasingly discredited, if not outright banned, whether in the 1928 Kellogg-Briand Pact or the 1945 UN Charter. In 1941, federal FDR, right, Franklin Delano Roosevelt and Churchill issued the Atlantic Charter, which renounced, quote, aggrandizement, territorial or other, and expressed the desire, quote, to see no territorial changes that do not accord with the freely expressed wishes of the people concerned. So this seemed to kind of rule out the possibility of conquest still being a legitimate form of territorial acquisition. So against the backdrop of this discrediting of conquest, right, it's no surprise that Shapira and Shaki considered classifying these territories as conquered, only to both quickly reject this status. As Shapiro said, quote, Jerusalem is not enemy territory and we can never, and we have never and can never agree to this definition. That conquest connoted that the territory was foreign, right, further pushed to this immediate rejection, right? At the same time, these lawyers emphasized that any Israeli presence in the territories beyond the partition lines was a result of self-defense and in compliance with Article 51 of the UN Charter, which carved out a self-defense exception to the general prohibition on the use of force. So it was definitely not conquest in their view. The second option was that it was some type of trusteeship, ne'emanut. So for similar reasons, they rejected the idea that Jerusalem would be placed under an Israeli trusteeship. So the idea of placing Palestine under a trusteeship had many iterations during this period, right? Both in the last years of the mandate and even after the mandate expires, right? There are all these attempts to create a trusteeship. There's this idea of putting Jerusalem under an international trusteeship. So at this time, there were also some American Zionists that suggested that Israel voluntarily assume or voluntarily announce that it would administer Jerusalem under a trusteeship. Shapiro argued that this was inappropriate, however, right? So he analogized the trusteeship here, right, to the trusteeship in the form of the League of Nations mandate. For him, his argument was that this was inapt because when the British accepted the League of Nations mandate, they had actually acquired the title to Palestine through conquest, and then they traded in that title. They gave that to the principal allied powers in return for the mandate, right? And yet, since Israel hadn't acquired the territory through conquest, right, the idea that they needed to hold the territory in trust was also inappropriate, right? So again, no conquest here, no need for a trusteeship. The third option was terra nullius. So this is a concept, right? It's supposed to be from, the Latin, of land where there's literally no one. So the concept here, the history of this concept and whether it was acquirable in the first place by dint of being quote unquote discovered or had to be continuously possessed is controversial. The idea of terra nullius was prevalent throughout European colonization, it seems. Yet, in fact, the term itself was actually initially applied only to the polar regions in the world, and it only became popularized in the 1930s when a group of American international lawyers anachronistically invoked it to describe previous colonial expansion. So various concepts have been used that were similar to terra nullius, right, throughout the course of European colonization, from the 15th century onwards, right? But in fact, they rarely used the idea of terra nullius. They used oftentimes this idea of res nullius and this kind of idea of private property that did not belong to anyone, that could be acquired through private law, right? But the analogy to public law and the idea that sovereignty could be acquired was not really there. And only later do American lawyers say, oh, we think all this looks like terra nullius, and then they kind of anachronistically impose that category on time. Now, Israeli lawyers initially found this idea tempting, right? Not least because Zionist culture and discourse often depicted Palestine as a desert or barren land. Indeed, Shapiro cast the territory beyond the partition borders as, quote, more similar to an unknown land discovered by explorers than to a land conquered by a foreign army, right? So this idea of unknown land discovered by explorers seemed to resonate with terra nullius. Yet he quickly walked this back, recognizing that, quote, the problem is that these territories are not, in fact, very similar to a new country. Because not only, right, were these territories settled, right, there was also no competing sovereign claimants. The Israelis were not claiming sovereignty, nor were the Arab states apparently claiming sovereignty, right? And none of them were trying to stake their symbolic flag into them as discoverers had long done. So again, terra nullius has this appeal, but they kind of say, no, ultimately that's not. So what this did is it left kind of two kind of other options. So the fourth option, the kind of more appealing option, was this idea of territorium nullius, right? So this is land that is inhabited, but it's lacking a territorial sovereign. So this concept was also related to terra nullius, again, derived from res nullius, but it denoted inhabited land without a territorial sovereign. This idea was first developed during the European colonization of Africa in the 1870s and 1880s, right, the European scramble for Africa. It was used both as a means of legitimating that conquest and as a means to criticize it. The idea here was that there was no existing sovereign, or at least state or quasi-state sovereign in the territory, and that therefore the territory could be acquired through what was termed, quote unquote, effective occupation. What appealed to Shockey and Shapiro was that this concept both offered a pathway to acquisition and that it did not require that there be an acknowledgement that Israeli forces were in foreign territory or there by dint of aggression or conquest. They and others emphasized the fact that with the termination of the mandate on May 15th, there was no Arab state that emerged in the territories allocated in the partition plan, and that therefore there was a vacuum in sovereignty, it would seem, or at least a vacuum in the administrative capacities of any state in these territories. At the same time, they recognized that the partition plan was seemingly applicable, and therefore, absent an Israeli renunciation of this plan, they could not move to acquire the territory. Right? So especially in the early period, Israelis don't want to renounce the partition plan, right? Even as facts on the ground are unfolding that make it basically impossible to implement, right? But they don't want to be the first ones who say, oh, right, we are going to take over Jerusalem permanently or take over other areas. So what happens is there's this appeal, right? And they want to claim that there is an absence of sovereignty, and therefore they are not infringing on anyone else's sovereignty, right? But once they do that, they would be implicitly, right, or explicitly renouncing the partition plan, right? So they see an appeal here, but they don't fully embrace that kind of category. Instead, what they do is that they recognize also that, right, what they can do is classify these territories as belligerently occupied territory. So belligerent occupation is a concept that develops in the 19th century to govern intra-European conflict. It's eventually codified in the 1907 Hague Convention, and Article 43 of the Hague Convention states, quote, the authority of the legitimate power having in fact passed into the hands of the occupant, the latter, the occupant, shall take all measures in his power to restore and ensure as far as possible public order and safety, while respecting unless absolutely prevented the laws in force in the country. So like with territorium nullius, belligerent occupation triggering this Article 43 requires quote unquote effective occupation. Yet rather than solely empowering the occupant, as would be the case perhaps in Africa, right? Once you have effective occupation, you can move to claim some type of sovereign title, right? Under this scheme of belligerent occupation, once there was effective occupation, right, then there were duties that were imposed on the occupant to ensure that the occupation just remained temporary, right, and did not only last during the course of hostilities until the end of the war. So under the Hague Convention, right, this territory would be placed under a military administration that was separate from the occupant's formal governing entity. State, an occupying state, right, but they would place that territory under some type of military administration, right, and not under their own government's administration, right, to demarcate the fact that it's just there temporarily. As Article 43 makes clear, right, existing law was to remain in force unless absolutely prevented, right, for the sake of public order and safety. So that said, circa 1948, and this is prior to the Geneva Conventions, which kind of come into effect in 1949, there's no explicit and agreed upon prohibition on the idea that you can annex territory that does not result from conquest. So conquest is not permitted, aggressive war is not permitted, but it's not clear, right, that annexing territory that is not acquired via conquest is not permitted, right? That only becomes kind of, in the 1960s, that becomes an international legal prohibition, right? So in turn, what they argued is that for the meantime, Israel could classify the territory as belligerently occupied, right? It would effectively occupy this area, right? And then once the hostilities ended, they could move to annex these territories, given that they were not engaged in conquest and as part of a broader peace agreement. So the bottom line is that Shockey and Shapiro conclude that the territories are best understood as resembling somewhat this territorium nullius, right? But for the time being, it's more expedient to engage in this, to apply the framework of belligerent occupation, right? So like territorium nullius, there was no government or sovereignty in this territory. At the same time, and unlike territorium nullius, it was allocated to an Arab state under the partition plan. Meanwhile, like belligerent occupation, Israeli forces were in territory that was not clearly part of Israel. But on the other hand, they were not there by dint of an Israeli belligerency, right? It's something that they insisted. Right, so against this backdrop, they advised that they treat the territories as belligerently occupied in the short term, thus adhering to Article 43, while also looking in the long run to the possibility of turning this territory into Israeli territory. So importantly, this view, right, and its restrictions on directly extending Israeli law beyond the partition plan borders initially seemed to triumph. So especially during June 1948. So there in the archives, there are kind of a variety of instances in which that show that, right, adopting this framework has consequences on the ground, but I'm just going to briefly mention one. right? So in the period both before and after May 1948, as Palestinian flight is most intense, there was a huge problem of Jewish soldiers and civilians looting Palestinian property. In response, Bechol Shalom Shitrit, who's the first minister of minorities, proposes legislation that would empower Israeli ministers to enact regulations to quell the looting and punish the looters. This eventually passes in June as the Pekudat Shetach Natush, right, the abandoned territory ordinance, one instance of euphemistic language that featured during this period. But once it's passed, the legislation is never actually implemented via regulations. This is in large part because of kind of inter-ministerial competition, but also because there's a lot of opposition from government lawyers who say that any direct extension of Israeli law to these territories, which were outside of the territory allotted to the Jewish state, right, would be a clear violation of Article 43. So Minister of Justice Pinchas Rosenblit informed Shitrit that the ordinance's provisions empowering ministers to issue regulations constituted, quote, an intervention of a minister of a foreign state in the responsibility of a military commander in a conquered territory, and stands in contradiction with international law. Right, so under international law, right, it could only be the military commander who asserted laws in these areas via kind of military edict. It couldn't be the government, the Israeli government, that was imposing. Rosenblit further warned that such actions amounted to quote unquote annexation of territory, and even referenced the Nuremberg trials, noting that similar measures were included in the charges brought against Hermann Göring. So what starts to happen, though, at this time is that there starts to be pressure to apply Israeli law outside of these territories. So in early July, there start to be cracks that start to appear in this, what I call kind of the occupation view. So for one thing, Israel's military extended its control over more territory not included in the partition plan. These military successes emboldened the Israeli government, which felt increasingly confident in gradually breaking with the partition plan and enshrining the facts on the ground. For another thing, within those territories held by Israeli forces, demands began to be made for the imposition of law and order by civilians. And this is especially the case in Western Jerusalem. So on May 16th, Binyamin Halevi, so that's one day after the State of Israel is established, Binyamin Halevi, who served as a magistrate judge in Jerusalem and Tel Aviv and would eventually preside over the Eichmann trial, reopened the Jerusalem District Court, along with Chaim Cohen, who would go on to serve as the state attorney, director of Ministry of Justice before becoming the attorney general and later a Supreme Court justice himself. Yet even as the court was opened, right, it was neither clear under what jurisdictional basis it was being opened, right? Who had the power to open it? Was it part of Israel or not? Nor which body of law was to be applied. Was this court to apply mandate law and operate by dint of the mandate legal system in Article 43's framework for maintaining the existing legal system? Or was it to be cast as somehow part of the new Israeli state? And under the Israeli legal system, even though West Jerusalem was not slated to be part of the Jewish state under the partition plan. So this uncertainty became even more pronounced in the middle of July when the paramilitary organization Etzel detained several British nationals in Jerusalem on charges of espionage. Eventually, these Britons were handed over to the Haganah, or the IDF, the Israel Defense Forces, and two of them were ultimately indicted and slated for trial. So William Hawkins and Fred Laird, William Sylvester. So the prospect of bringing them to trial, however, required that Israeli government officials iron out the status of West Jerusalem, given the question of whether they had jurisdiction in the city in the first place, and whether it could be said that the Britons were engaged in espionage against Israel. So in July, a few options emerge as to how to treat these territories. So on one end, we have Shaki, who insists that Israel continue to treat them as belligerently occupied. Here, the military commander, or under this scheme, the military commander would announce that the city was under his authority and under military rule. On the other extreme was Halevi, who argued that the Israeli provisional government directly legislate and assert that the courts operated by dint of Israeli law. This was because he argued, quote, the Jerusalem area does not currently belong to any state, but is rather territorium nullius, end quote. Extending Israeli law to the city, he argued, would not, quote, hurt the sovereignty of any other state. A seemingly middle ground approach was put forth by Shabtai Rosen, who at this time was a legal advisor to the Jewish agency. He was already considered a rising legal star within the Israeli kind of government ranks. He would later become an ambassador and member of the UN-created International Law Commission. So Rosen argued that military rule should be declared in the city, but crucially, that it be the Israeli provisional government, not a military commander, that issued the proclamation establishing military rule, right? And that in the same proclamation, Israeli law be enacted in the city during, quote unquote, the transitional period. So Rosen's approach, right, would thereby adopt the language of belligerent occupation, right? This is under military occupation, right, and claim that there was military rule, while in fact extending Israeli law to the city in violation of Article 43 of the Hague Convention. Now, there's several interesting things about this. One of the things that's interesting is that Rosen clearly understood what he was doing. He'd already written about Article 43, and he exhibited a deep familiarity with the law. And also, and this is kind of looking forward, when Israel occupies the Gaza Strip and the Sinai Peninsula during the 1956 war, he strongly advised the government to abide by the Hague Convention and warned that, quote, a clear sign of a state imposing its sovereignty on occupied territory is the imposition of the occupying state's laws on the occupied territory, along with the invalidation of the laws that were previously enforced and originated in the prior sovereign. So there are a whole variety. He doesn't explain why he thinks that this situation warrants Israel extending its jurisdiction. Perhaps he thought it was the provisional nature, that it would only be a temporary mechanism. Perhaps he thought that, oh, there was no prior sovereign that existed, so Israel, again, was operating on this clean slate. Perhaps he just thought that kind of political expediency was necessary here. Now, what happens is kind of gradually over the course of kind of July and eventually August, Shabtai Rosen's system or his strategy works out. So in early August, and we can't really see, so apologies, but in early August, the provisional Israeli government formally embraces this strategy of declaring West Jerusalem occupied territory. At the time, it calls it Shetach Muchzak, right? But you can all, if you look very closely here, right, when it's translated into English, these orders, right, it says occupied territory. So they define West Jerusalem as occupied territory while simultaneously departing from the requirements of Article 43 of the Hague Convention. First, by having Ben-Gurion, in his capacity of Minister of Defense, issue these, right? So Ben-Gurion is a civil official, issues these rather than a local military commander. And second, by stating that Israeli law will apply in Jerusalem, right? So importantly, it used this term Shtachim Muchzakim, which is different from the term of Shtachim Kvushim. Kavush is kind of literally conquered, but oftentimes it's used to describe occupied territory, to designate these occupied territories. Right? So they use Shetach Muchzak already. So the term Muchzak means hold, right? To hold something, lachzik, or to possess something, right? And following Shaki's earlier use of the term Muchzak to denote occupation, right? They translated it as occupied territory. In early September, the government follows this up with a similar proclamation regarding other territories within the borders of Mandate Palestine, but outside those allotted to the Jewish state in the partition plan. So they also apply, they call these occupied territories, and they apply Israeli law to those. And those are the areas in red. Now, the third and final stage here, right? So right now we have kind of Israeli law, right? So there are territories that are within, right, that are just not seemingly defined. There seem to be, right, shtachim of like the territories of the state of Israel. Then there's occupied territories. Israeli law applies to both of them right now. Now the third, so now the third stage is kind of redefining this from Shetach Muchzak. So this starts to unfold in September. So the proclamations that Ben-Gurion issued, extending Israeli law, turned out to be both unsatisfactory as a matter of both international law and Israeli municipal or constitutional law. So when it came to international law, the one who was supposed to issue the proclamations was not Ben-Gurion, but the military commander. Meanwhile, when it came to Israeli law, it was equally problematic that these proclamations had been issued by Ben-Gurion. After all, if these proclamations were to have the force of law, right, they had to be issued by the legislative body, the Israeli Provisional State Council, the Moetzet Ha'am, right, and not by an executive official. As Shapira, this is Yaakov Shimshon Shapira, himself recognized, quote, there is no mention in the laws of the state of a directive that allows a minister or even the entire government to impose the state's law on any country outside of the state, end quote. This suggested that the declarations were invalid and that Israeli law was not in fact in force in West Jerusalem or the other so-called occupied territories. To make matters worse, if the proclamations were infirm, then Israel also lacked the jurisdiction to exercise the various governmental functions that state-appointed authorities were carrying out in these territories. And one of these functions was trying the British nationals who had been accused of espionage. With this trial approaching, right, as Shapira and others anticipated, that the question of the Israeli court's jurisdiction in Jerusalem and the applicability of Israeli law would be raised by these defendants and would have to be addressed by the courts. So with the trial slated to begin in October, Israeli officials raced against the clock and scrambled to find a new legal mechanism through which to extend Israeli law jurisdiction more securely to West Jerusalem and the other territories beyond the borders of the UN's Jewish state. This paved the way for a new legal framework, classifying these regions not as occupied territories, but as administered territories. So ironically or not, it was Shaki and Shapira who laid the groundwork for the shift. Since the time that he insisted, when he wrote those early memos insisting that Israel adhere to Article 43, Shaki had also penned a number of other memos that gave voice to the view that Israel's creation not only had not followed the UN partition plan's template, but also that it did not follow other states' models and was therefore sui generis. He further opined that the mandatory government had engaged in a quote-unquote instance close to dereliction when it left Palestine. And given the failure of both the partition plan and the British abdication, Shaki argued that Israel fell within the category of states that, quote, arose unilaterally on the basis of their own will and power. So in turn, he moved to redefine the terms shetach muchzak. So previously understood, especially in his own works, right, as the equivalent of occupied territory in the Hague sense of the word, right? It would now, Shaki admitted, take on a quote-unquote special meaning, right? Which he added was obviously somewhat different from the accepted meaning of the term occupation under the Hague regulation. What is more, he argued that this was fine, since Israel was not harming, quote, the rights of any sovereign state with which it was at war, right? So the Hague didn't really have to apply. After all, these territories did not have a sovereign, but were only reserved for another state or designated for another state, right? So long as Israel maintains some form, quote unquote, some form of line, of a separating line between the territories within the state of Israel and these other territories, he concluded, it would be respecting whatever sovereign rights the other regime could lay claim to. This line might exist only in language, a distinction between the, quote, territories of the state of Israel and the, quote unquote, shetach muchzak. Meanwhile, Shapira offered kind of a full-throated defense of a proposal of a law that would apply Israeli law directly to these territories. So this proposed law, which was drafted in late August, was criticized by Dov Yosef, who was then the military governor in Jerusalem. He was also kind of the big legal mind of Mapai. Dov Yosef had argued that this was violating international law and that it was very kind of two-faced, right? That they were claiming they were using this language of international law, but in fact violating it. And Dov Yosef came out and said, we can't have it both ways. Shapira argued, yes, we can. That Dov Yosef didn't really understand what was going on here, right? He argued that because Jerusalem, so this is Shapira, argued that because Jerusalem was not occupied by Israeli forces, right? There was not an occupation here. There was no need to strictly adhere to, quote, Article 43 in all of its detail, end quote. Furthermore, he stated that Israel had as much sovereign power as other states to extend its jurisdiction even to areas outside of its territory. Here he drew a provocative parallel. He cited the British Foreign Jurisdiction Act of 1890, which had provided Britain with legal authority as a domestic matter to exercise jurisdiction over foreign territories in which it did not formally claim sovereignty, whether informally through extraterritoriality, right, as in the Ottoman Empire, China, and Japan, or as de facto colonies or protectorates, as in Africa. So just as that act, quote, permitted in English law for the English king, apologies, to rule foreign countries that are not his, then the state of Israel, by virtue of an ordinance from the state council, can rule in Jerusalem. Okay, so this comparison was striking for kind of several reasons. First of all, the Foreign Jurisdiction Act had been instrumental in extending British jurisdiction throughout its various protectorates, including those which it claimed a right to through territorium nullius. By aligning the exercise of Israeli jurisdiction in West Jerusalem with British rule over protectorates or territories that were purportedly territorium nullius, Shapira implicitly and even explicitly cast the legal logic of Israel as continuous with its predecessor. Finally, he argued that even if extending Israeli law to Jerusalem and the other territories was illegal as a matter of international law, he was far less concerned about those, right? Quote, the complications that will arise after the war in terms of international law might be addressed in a future peace settlement. By contrast, quote, the complications that will emerge at present in our courts were immediate and dangerous. Without proper legal grounding, the proclamations were at risk of being struck down by Israeli judges. Now, Shapir and Shaki's argument set forth this motion, it set in motion the process under which the Areas of Jurisdiction and Powers Ordinance 1948 is passed into law in mid-September 1948. And under this law, every Israeli law that applied within the state of Israel was said to apply, quote, to all of the territory that included both the territory of the state of Israel and any part of Eretz Yisrael, which the Minister of Defense classified by a proclamation as muhzak by the Israeli Defense Forces. Okay, so that's the law, right? So the official translation into English then defines muhzak not as occupied, but as held or administered, right? So though the precise legal significance of this term, administered, remained murky, it was clear somehow that shtachim muhzakim were not synonymous with occupied territory. As other Israeli lawyers and politicians would acknowledge, in putting forth this term, Israel, quote unquote, has created a new international legal concept. Right? Indeed, when the Israeli Supreme Court issued its ruling in the British spy case, right, it pointed to the Areas of Jurisdiction and Power Ordinance as providing jurisdiction in Jerusalem, right, and retroactively applying, right, so that as a matter of Israeli law, right, the state had jurisdiction over these individuals, and the acts of espionage that they had carried out could be seen as against the Israeli state. They found them innocent on other grounds, right? They kind of re-examined the evidence and found that the lower court had in fact kind of misread the evidence and that it did not meet the substantial standard that it needed to, which in and of itself was pretty extraordinary. Now, there's much more to say about this legal framework applied, but for the sake of time, I just want to kind of make 4 concluding remarks. So first, the shift here to administered territories was predicated on the idea that there was no need to adhere to Article 43 of the Hague Convention. As one lawyer, this is Uli Elin, who was very influential in drafting legislation during this period, noted in a broadcast at the time, in passing this ordinance, the Israeli government affirmed that when the IDF captured towns like Ramle, Bet Susin, and Shafaram in the north, and Hita or Tia in the south, it captured them neither from a foreign state nor from a ruler with any form of a constitutional government, but took hold of territorial nolius, Nieman's land, no man's land, Shetach Hefker, and established a unique original administration. Second, although the archival record on these are still classified, it appears that Israel extended its classification of these quote-unquote shtachim muchzakim, these administered territories, to all of the territory that fell within the state of Israel's control under the armistice agreements signed in 1949. So as Shabtai Rosen stated in 1956, right, according to the information I have, the red lines on the map, right, which becomes the green line, right, those are permanently altered. Those delineate the administered territories, and they're permanently altered by the Israeli government following the territorial changes agreed to in the armistice agreement. The armistice agreements were therefore accepted as a necessary foundation for the state on which the legal conclusions that realize the internal and external sovereignty of the state are based. So even though the armistice agreements were kind of explicitly stated that they were not political borders between Israel and the various Arab states, Israel, as a matter of Israeli law, essentially treated them as such. Right? So anything that fell within them was either Shetach Medinat Yisrael or Shetach that was determined to be muhzak by the Saudi Bichon. Third, after extending Israeli jurisdiction, Israel also established what is known as the military government in areas that were predominantly Palestinian. So in my research, I traced the process in which the system was created in more detail. But for now, I just want to note that it was entirely predicated on Israeli law, right? So this is not a military regime in the Hague sense of the word, right? Rather, it's simply an Israeli regime, and they have the military administer the occupation or administer the administration of these territories through British cum Israeli laws, especially emergency regulations. So there was also this whole kind of legal mess with the system kind of folding out, the system actually lacked kind of a proper legal basis as a matter of formal Israeli law into the mid-1950s, that is a year and a half after the war ended, and only later was it ironed out. Fourth and finally, a similar dynamic, right, plays out here in 1967. Right, so at first, aside from East Jerusalem in 1967, which was annexed through a different legal mechanism almost immediately by the Israeli government, Israeli legal officials moved to classify the territories that were conquered in 1967 as occupied and under the Hague and Geneva Conventions. It was only gradually that they moved to make novel arguments about why these territories were not in fact occupied, but were rather shtachim muchzakim, or administered territories. Importantly, Israeli law was never directly extended to these territories, and that's in contradistinction to those that I talk about in this period, right, those within the Green Line. Right, notwithstanding this crucial difference, right, here too, Israeli lawyers engaged in what one can call legal innovation, acrobatics, or outright law breaking, as they moved to create a regime that did not adhere to extant international law. So just in conclusion, and kind of trying to, gesture towards some of the historiographic contributions here. Right, so the project kind of aims to zoom in on the establishment of Israel's territorial jurisdiction after 1948 and show how this complex process unfolded over time and was shaped by shifting legal interpretations, right, political realities, and also kind of military necessity. In so doing, it seeks to first tell a story that has largely gone unnoticed in scholarship. Much of the debate and scholarship is focused on 1967, right, but this paper shows, or this article shows, right, that many of these debates about the supposed novelty of the legal status of Mandate Palestine and Israel already emerged in 1948. So I'm also interested in connecting this transition in 1948 to the transition that occurred between the end of the Ottoman Empire, right, and when the British take over, conquer Palestine and impose a military regime between 1917 and 1920, that then is shifted towards a civilian regime before the mandate becomes recognized in 1922, 1923, right? And the exact legal basis and the justifications there are also kind of very questionable or kind of unclear exactly how that sequence follows, right? But what we see both in these three time periods is that, initially there's kind of a recognition of the application of Hague, right? And then there's some kind of creation of a civil administration or some type of new legal category that does not adhere to that. Finally, I think that this project kind of both, it speaks both to kind of historiography that looks at Israel's ambivalent and instrumental relationship with international law, and also the historiography that probes how international law, right, is not something that's just exists out there, right? It's constructed and reconstructed over the course of history, especially during the 20th century, and it was and continues to be like a field of innovation and contestation, both during periods of European empire and after their formal demise. So I look forward to.
Yeah.
Just want to end by thanking Professor Stern so very much for sharing this incredibly rich and very meticulous and very still timely research with us. And thank everybody who joined us today for doing so, and invite you please to check out the Schusterman Center website for the many events we have coming up. Thanks, everybody.
Well,